Hello everyone. Welcome back to our channel, where learning meets excitement. The next important topic is the very important fundamental rights. The fundamental rights are enshrined in Part 3 of the Constitution from Articles 12 to 35. In this regard, the framers of the Constitution derived inspiration from the Constitution of USA. Bill of Rights. Part 3 of the Constitution is rightly described as the Magna Carta of India. It contains a very long and comprehensive list of justiciable fundamental rights. The fundamental rights are meant for promoting the ideal of political democracy. They prevent the establishment of an authoritarian and despotic rule in the country, and protect the liberties and freedoms of the people against the invasion by the state. They operate as limitations on the tyranny of the executive and arbitrary laws of the legislature. Originally, the Constitution provided for 7 fundamental rights: right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to property, right to constitutional remedies. However, the right to property was deleted from the list of fundamental rights by the 44th Amendment Act, 1978. It is made a legal right under Article 300A in Part 12 of the Constitution. So at present, there are only 6 fundamental rights. Features of the fundamental rights guaranteed by the Constitution are characterized as the following. They are not absolute but qualified. The state can impose reasonable restrictions on them. However, whether such restrictions are reasonable or not is to be decided by the courts. Thus, they strike a balance between the rights of the individual and those of the society as a whole, between individual liberty and social control. Some of them are negative in character, that is, place limitations on the authority of the state, while others are positive in nature, conferring certain privileges on the persons. They are not sacrosanct or permanent. The Parliament can curtail or repeal them but only by a constitutional amendment act and not by an ordinary act. Moreover, this can be done without affecting the basic structure of the Constitution. They are defended and guaranteed by the Supreme Court. Hence, the aggrieved person can directly go to the Supreme Court, not necessarily by way of appeal against the judgment of the high courts. They can be suspended during the operation of a national emergency, except the rights guaranteed by Articles 20 and 21. Further, the 6 rights guaranteed by Article 19 can be suspended only when emergency is declared on the grounds of war or external aggression and not on the ground of armed rebellion. Most of them are directly enforceable, while a few of them can be enforced on the basis of a law made for giving effect to them. Such a law can be made only by the Parliament and not by state legislatures, so that uniformity throughout the country is maintained. Thank you for joining us today. Be sure to like and share this video. Don't forget to subscribe to our channel for more enlightening content. Until next time, stay curious and keep learning.